On behalf of the City of Vincent, I pay my respects to the traditional owners of the land, the Whadjuk people of the Noongar Nation, and pay our respects to elders past, present and emerging. And I should declare the meeting open at 6 p.m. I'd like to welcome members of the public gallery to tonight's meeting. Just to let you know that we do web stream our council meetings, which are then put onto our website, but we don't record and transmit the public question time part of the proceedings. So when you're speaking, you're not recorded, just to let you know. Before we get to public question time, I'll just go to apologies and members on approved leave of absence. We do have Councillor Loden, who will be arriving late this evening, and we also have Councillor Ros Harley running about half an hour late too. So thank you for that. So it's now time for public question time. There's no order, it's just whoever comes up to the microphone first. You're all very welcome. We do invite you to speak for up to 3 minutes, and we do time to keep the meeting running smoothly, and we do ask that you state your name, your address and the item to which you're speaking to this evening. So would the first speaker please like to go ahead? Yes, you're welcome. Response to previous public questions taken on notice.
Yes, we do, Mayor Cole. There was just one question from the previous council meeting, and a response to that was provided to Mr Dudley Mayer, and that was on the 29th of January. I understand copies have been provided in the agenda papers.
Thank you, CEO. Also, just to note that live streaming of the council meeting has commenced, so if anyone is tuning in, we do welcome you to the meeting. Do we have any applications for leave of absence, CEO?
No, Mayor Cole, I've not received any.
Receiving of petitions, deputations and presentations. Neil?
No, we have none.
Okay. Now we'll move to confirmation of minutes. So we have the ordinary meeting of the 12th of December 2017. If I could please have a mover and seconder to adopt the minutes. Moved Councillor Murphy, seconded Councillor Hallett. All those in favour? I declare it carried. Announcements by the presiding member. I do have a few announcements this evening. There's a couple of exciting things happening around the City of Vincent. The first I'd just like to talk about is that we are just about to embark on our second round of the Lady Streets Open, which is where we close Leaderville to cars and make it accessible only to people, potentially some pets as well. So this is something that we ran in March last year. We found that businesses who engaged with this really benefited from it, and we saw that we managed to attract a lot more people to Leaderville, and that they did stay longer and enjoy being able to spill out onto the streets. So this year we have 17 local businesses participating, and we're also running it to coincide with some really exciting events in Leaderville, namely Leadypalooza, which is for the first time a Leaderville branch of the Fringe Festival, which is specific to Leaderville, and there's some really exciting things happening like the Unfair Day and Boxville, and also dancing on the streets. And then we also have it coinciding with an AFL pre-season game with the Eagles and Port Adelaide, and then we also have a long weekend. So 4 Sundays of street closures in Leaderville. I do encourage everyone to come down, because the atmosphere without cars is really quite something to experience. It really does transform the streets. Also, just to give an update on Hyde Street Reserve, this is a capital works project which is proceeding at the moment, and it's part of our council's priority to create more inviting green and open spaces. This is our first Parks from Roads demonstration project, where we are literally digging up a road that is not particularly well utilised next to Hyde Street Reserve and doubling the size of the park, and that we've been doing this with support of the immediate neighbours to the park and the community surrounding that, in order to create a more public open space and more park within Vincent. So at the end of the project we will have doubled the size of that neighbourhood park. I'd also just like to say that we are for the first time celebrating Chinese New Year on William Street on Friday the 16th of February. We're going to be welcoming the Year of the Dog, and we will be spending some time on William Street, staff and councillors greeting people, talking to traders, giving out some free fortune cookies. So come on down to William Street and experience the New Year celebrations. And finally, just to much to the delight of John Patton, I'd just like to acknowledge that this is our Director of Corporate Services' last meeting in the chair as Director, and that while John does like to have the spotlight shone on him, thought I'd take the opportunity just to say a few words. That John has been in the Director role for 3 years. He did start with us in early 2015, and at the time he did walk into a situation where our financial situation did need a very good and stern hard look at it. So I think that John has achieved many things in his short time in the role, but most significant of those being bringing our finances into the black very firmly and with a very positive, healthy and sustainable future ahead of us. He's had a very strong focus on asset sustainability. He was instrumental in us setting up an asset sustainability reserve and long-term planning around that, and he also has helped us to get our leases in order. John, I think that the rigour, the tough love approach that you bring to the role is very valuable. You've been a very strong and able advisor, and I'd also like to say that you have sometimes affectionately been referred to as General Patton for your tough and firm approach. So look, you're not able to slip out unnoticed. We did have to stop and pause and say thank you very much for a job that has been extremely well done. We'll miss you in the role. Thank you. That's over now, John. So move on. Okay, so moving on to declarations of interest.
Thank you, Mayor Cole. We have two. The first is a proximity interest disclosure from Councillor Josh Toppelberg in relation to item 9.3 Smith Street, Highgate. Councillor Toppelberg has disclosed that the extent of his interest in this matter is that his parents own and reside in a property opposite the site of the application at 34 Broome Street, Highgate. As a consequence, there may be a perception that Councillor Toppelberg's interest is affected. Councillor Toppelberg is not seeking any permission from Council to participate in the debate or remain in the chamber or vote on the matter when it is discussed. The second disclosure of interest I've received is from Mayor Cole. It is a impartiality interest disclosure in relation to item 9.7, Anzac Road, Mount Hawthorn. The extent of Mayor Cole's interest in this matter is that she is an owner-occupier of a property located on the right-of-way on which the proposed group dwelling is proposed. Mayor Cole's property is not a neighbouring or adjoining property to the development site. Nevertheless, as a consequence, there may be a perception that Mayor Cole's impartiality on the matter could be affected. Mayor Cole has disclosed that she will consider the matter on its merits and vote accordingly.
Thank you, CEO. In addition to the items that have been raised by the public gallery and the absolute majority decision items on the agenda, I'll just go around the chamber to see whether council members wish to bring forward any other items. Councillor Hallett, do you have any further items to raise?
Yes, sorry if I've deleted absolute majority off my list, so I might say those. 9.2, 10.1, 13.1 and 11.5 and 14.1.
Jonathan, the CEO's Councillor Hallett, the CEO's requested if you could just run through those again. You don't need to call out the absolute majority ones, they will automatically be considered by council. But can you run us through again? Thank you.
Sorry, I don't have the absolute majority noted on my...
That's fine, you just go for it.
9.2, 10.1, 13.1, 14.1 and missed 11.5.
Thank you, Councillor Hallett. Councillor Castle?
No, mine are already covered in the list, thanks.
Thank you. Councillor Harley? Councillor Murphy? Councillor Fotakis? Councillor Toppelberg?
Just 11.3, standing orders, thanks.
Councillor Gondaszewski? Okay, thank you. So what I will now do is I'll ask a CEO to go through the items that will be moved en bloc.
Thank you, Mayor Cole. For the benefit of members in the public gallery and also anyone streaming at home, the following items will now be adopted by Council en bloc as per the officer recommendations. 9.5, 9.6, 9.7, 9.8, 9.9, 11.1, 11.2, 11.4, 11.7, 12.1, 13.2 and 13...
Sorry, I just should say, sir, I'll pull forward 13.1 because there is an amendment on the table from Councillor Loden.
Yep,
So
Councillor Hallett already requested the exclusion of item 13.1.
Okay, thanks.
So that then just leaves 13.2 and 13.3, noting that that excludes the items that councillor members have just requested be discussed separately. It also excludes the two matters that public questions have been raised on, which were items 9.4, 9.10, and finally, as the Mayor's already mentioned, it excludes absolute majority decisions where they are required.
Thank you, CEO. Can I please have a mover and a seconder to move the en bloc items? Moved Councillor Murphy, seconded Councillor Castle. All those in favour? Declare the en bloc items carried. So what we will now do is that we consider items first that have been raised by the public gallery. So the first item that was raised in the public gallery tonight was item 9.4, which is number 14 Florence Street, West Perth, change of use, single house to unlisted use. Do I have a mover and a seconder for this item, please? Moved Councillor Gondaszewski, thank you. Seconded Councillor Hallett.
Thank you, Mayor. I just have a question in relation to some of the comments from the floor in terms of the other applications that for the adjoining lots. There was some commentary in relation to intrinsically linking between developments, and I just wanted to get some comments from the Director of Development Services in relation to, I guess, just to confirm in relation to what the parameters of Council's decision making is tonight on this issue, and how that may impact or I guess whether that is able to have an influence on subsequent decisions in this related sites.
Yes, through you, Mayor Cole. This application is standalone from the other applications. Council needs to consider the change of use for this existing building on its merits. Now, the context of the other applications is something that administration did consider. The parking, for instance, has been located such that it won't undermine access down the left-hand side of the property if that's something that ultimately the owner and the applicant of the other applications decides to consider. So it doesn't prohibit that. So without requiring the building to be knocked down, that which is given its status, that's probably the extent of consideration that can be given to this proposal. So the parking's been deliberately located in front of the building so that it doesn't restrict that access, and it allows for the maximum amount of flexibility as part of those other applications. But I just reiterate that this is an application that's standalone, and Council needs to consider it in isolation of the other applications, which will be subsequently considered by Council or the DAP at the appropriate time.
Just one further question in relation to, I note that it is proposed that 3 of the bedrooms will be used for accommodating guests, and the fourth bedroom will be allocated for the use by the keeper, who will be responsible for the upkeep and management. Should that change in terms of wanting to turn over that bedroom to being for guests, how would that impact on this approval? Does that influence the management plan of the property?
Yes, through you, Mayor Cole. The plans would change themselves. They've made it very clear that those 3 bedrooms are the only 3 bedrooms that will be used as part of the short-term accommodation. So if they wanted to use that 4th bedroom for short-term accommodation, they would need to seek an amendment to their approval or a new approval to change that fundamental aspect of the proposal.
Thank you. Look, I think on this one, I'm happy to support the recommendation. And I think that we have a management plan of code of conduct, and I'm satisfied in relation to having a person on site to ensure adherence. And so in this instance, on the basis of this application going forward, I'm happy to support the recommendation.
Councillor Hallett? Oh, no? You just don't wish to speak? Okay. Any other comments in relation to this application?
Excuse me, Mayor, just one question through
yes,
you.
Sure.
In regards to, just following on from Councillor Gontaszewski's question about the 4th room, would that decision come back to Council or would that be done under delegated approval?
Yes, through you, Mayor Cole, if the applicant sought to amend this approval, then it would come back before Council. If they sought an entirely new approval, under the current scheme, obviously it would come to Council. It requires an absolute majority decision. Under the new scheme, that's something that Council will decide as part of the delegation, the decision to amend the delegated authority register in accordance with the new scheme, which is something Council will consider in coming months.
Councillors? Just to make a few comments, I understand that this is a pretty non-contentious application in that it is, when we treat it in isolation, in that it is a MHI category B, which means it's on our municipal heritage inventory, and that this does propose to have a keeper in residence, which is always a good thing when dealing with any sorts of noise or those sorts of complaints that can come up with short-term accommodation. That I think that in terms of the flexibility around the parking, I do think that is a critical factor, and I am appreciative of our development services team for picking that up in the context of the other 2 applications. And as always, when we deal with these matters officially, then we do have in place a management plan and a parking management plan, and also that this application in and of itself did not receive a response during advertising. And just to reiterate again to the members of the public that have come in, that in terms of the other applications, you know, please do get in contact if you wish to talk about those in more detail. So as this stands alone, I'm happy to support the recommendation. Unless there are any further comments, I'll put the recommendation. All those in favour? I declare it carried. Thank you for your attendance. Moving on now to item 9.10, which is number 7 of 565 to 567 Beaufort Street, Mount Lawley, proposed amendment to conditions of approval, change of use from office to recreational facility and office. Can I have a mover and seconder for this item, please? It's going to be a long night. Moved Councillor Gontaszewski, seconded Councillor Fotakis.
Thank you, Mayor. Just let me get my thoughts together on this one. I think that I have not. This issue. What we are considering tonight relates to the hours of 9 p.m. to 6 a.m. and I think that is in the forefront of everyone's mind. I think that it is clear from discussions with co-tenants of the site that they are impacted by the facility, but predominantly those uses do occur during the day. It has been brought to my attention and other councillors that there are concerns about noise relating to use during the night, and I think that warrants some consideration and further investigation. I have there is an amendment. I'm trying to find the colour. The amendment on the green. I will put the amendment. Oh, can I do that before the seconder has spoken?
Yes. Do I have a seconder for the amendment? Councillor Murphy.
Look, I think that in these sorts of issues, we need to ensure that we are approving usages and ensuring appropriate management. This amendment relates to the approval of a management plan. It's quite long, so I think it's on the screen. Essentially, it's requesting a new condition be inserted in relation to a management plan that covers the hours of 9 p.m. to 6 a.m. And this is really just to supplement some of the elements that are in place within the facility, such as signage that talks about the appropriate use of the facilities and the equipment in the facilities, and that also ensures that that members are aware that there will be compliance measures in place or some action taken if it is shown that the equipment isn't being used appropriately. And it also provides neighbours and co-tenants with a contact during the hours of 9 p.m. to 6 a.m. I think that if that management plan is implemented, I would hope that some of the concerns may be addressed, and also the impact of noise from the facility will be minimised. To that end, I would hope that after review of 6 months and at 12 months, it would be able to be seen that the management plan was addressing the concerns that have been raised in relation to noise, and it also allows the current issue in relation to nighttime noise to be investigated and hopefully addressed through both this management plan and then the review of the management plan, if we need to ensure that other elements are included in the future to essentially minimise impact on neighbours and co-tenants from the intensity of the use occurring between 9 p.m. and 6 a.m.
Thank you, Councillor Gontaszewski. Councillor Murphy.
Yes, look, I support this amendment. I think that it's a reasonable and responsible request. 15 noise complaints is a rather large number of complaints. There is obviously some impact that the gym's having within the immediate community, even though I do acknowledge that they are not exceeding any legal noise requirements. I think that this would be a great thing to do on behalf of Snap Fitness as a goodwill gesture towards the impacted neighbours. I think, I support the amendment.
Thank you, Councillor Murphy. Does anyone else wish to speak on the amendment? Okay, I'll put the amendment. All those in favour? Declare it carried unanimously. So I'll go back to the seconder of the substantive motion, and that was Councillor Fotakis. Do you wish to speak? No? Okay. And does anyone else wish to speak? We're back to the substantive. Councillor Hallett? Sorry.
Can I just ask a question to the Director of Development Services? I believe there was a recent noise complaint from a resident, and just wondering if you could comment on, any implications for that in relation to the report that was provided?
Yes, through you, Mayor Cole. In relation to the noise complaint made by the resident nearby yesterday, I think it was, or the day before, the city will investigate this complaint. The city doesn't have any record in its system of any complaints being received from nearby residents. That doesn't mean that a complaint hasn't been received over the phone or it hasn't been recorded somewhere in the system or correctly in the system, but the city certainly doesn't have any record of investigating residential noise affecting residential properties. So the city will contact this resident, have a chat to them about the details of of their concerns, and then undertake the ordinary compliance practices that it does in relation to noise complaints. So we'll get the resident to log the concerns that they've raised. We'll sit down with the operator and talk to them about the times that it's occurred, to understand what potentially is causing it, if it is their facility or if it's something else. And then we'll undertake some monitoring as well to independently verify the concerns. So that'll be the approach that we take. The noise regulations are quite strict in relation to residential impacts of noise on residential premises compared to commercial premises. I was mentioning earlier the limits around the max are about 80 decibels for a commercial premises. They don't change, as Ms Morridge mentioned earlier tonight. They don't change depending on the time of day. That's very different to an impact of noise on a residential premises, where the noise limits become very stringent as you enter the evening hours. And so I believe that we have strong powers through the noise regulations to ensure compliance with those limits on residential properties, such as the complainant's property who's raised these concerns yesterday or the day before.
So Councillor Harley was first, and then I'll come to you, Councillor Doppelberg.
Thank you, Mayor. I've got a couple of questions which I guess could be in general for 24/7 or gyms that operate in this way, but this one in particular, and occur a couple of questions being asked when this first came before Council. It relates, I guess, to security, but also a question about whether there is any other form of security by way of CCTV footage. What happens when injuries occur, or if somebody has an emergency on site? How is all that managed through a facility like this? And what are some of the ways that through the management plan they can ensure that illegal activity is not occurring on the site either? Not suggesting there is illegal activity, I'm just asking a question about how that gets managed in a site where it's not quite set and forget, but there's not a requirement necessarily to have staff in the facility 24/7.
Yes, through you, Mayor Cole. We visited the site today. There are a large number of CCTV cameras throughout the site, and the operator ran through the process that they follow when there are issues, in that they review the CCTV camera footage whenever issues are reported, and that generally they haven't had any concerns regarding security, theft or anything like that as a result of, I think, the process they go through when they have new members join, as well as the fact that there's CCTV cameras covering the entire of the inside of the facility.
Sorry, just one further question through you, Chair. So can I take from that then that that there's no live monitoring of the CCTV cameras in either this gym or in the chain of gyms? So it's only as matters get reported, yeah?
Through you, Mayor Cole, I wouldn't be able to answer that question. I'm not sure whether they are live monitored or not. We don't have that information at this stage.
Councillor Doppelberg.
Thank you. As annoying as it is, I think we've received some emails that suggest we perhaps have powers that we don't, and ultimately the issues that relate to the strata and the issues relate to the civil matters that may or may not be occurring in the building, and not in council's power to be able to resolve. And we can't. Well, we can be asked, but it wouldn't be proper for us to try and make a planning decision based on issues that may or not be occurring that we don't have any powers of control. So the only issue really in considering this for me is noise and the impact of noise. And I had spoken earlier to both the Mayor and Director of Development Services about potentially deferring a decision on this to allow noise monitoring to occur, particularly in the residential areas. The contention that was made earlier that because there's less people at night that there's therefore less noise doesn't hold at all, because someone dropping heavy weights when the surrounding locality is silent So somebody dropping heavy weights when the surrounding locality is silent does have a greater noise impact than when there is the general goings-on of a busy area in daytime and the early evening hours. I note there are people in the gallery shaking their head. I occupy an office that is 2 doors down from a gymnasium that uses free weights. I sit relatively adjacent to Fitzgerald Street, which is one of the busiest streets that exists, certainly within our city, and I both hear and feel the impact of weights being dropped during daylight working hours. I have a good relationship with the owner of the gym. I ring him when it occurs, and they obviously have a management plan which enables that to be ceased, but that's something I also understand because I know from other neighbouring properties that have made complaints that those tests, it is not exceeding the noise regulation. So I think that there's a fairness principle that exists, but that's something between the owner and occupier, or the occupier and their neighbours. That being said, given the comments earlier from the Director of Development Services in relation to the powers that we have in relation to the noise regulations, and should there be any breach, I don't see any need to defer a decision or otherwise, because in the event that we do continue to monitor, or at the request of surrounding residents, and if there are issues, there are powers available to the city to force compliance or ceasing of some of those operations. From what I have read and understand, I think that there are some noise mitigation measures in terms of sprung flooring that are able to be implemented. That obviously comes at a cost, but there are ways in which you can make free weight zones effectively silent in terms of their impact, both in noise and vibration. But that's something that, again, if it complies with the regulations, we don't have any power to enforce. So I will be supporting the officer recommendation as amended.
Councillors, further comments? Look, I just want to ask a question to the developer, the Director of Development Services. I'm not sure whether the applicant is aware that council members received a further complaint from a resident just late yesterday. I'm not sure if that information we've had time to pass that information on to the applicant, because it has been quite unexpected at that moment, and that council has not had the City of Vincent has not had an opportunity to investigate that complaint. Could you just walk council through, if we deferred the matter in order to investigate that complaint versus granting approval this evening, can you just sort of talk to us about what would the benefits be of deferral? Are there any benefits of deferral to allow for investigation of that complaint versus approving the application this evening and dealing with anything that comes from that complaint separately to the planning application?
Yes, through you, Mayor Cole, I'm not sure that they'll... look, council's responsible for making a decision on this application. Currently, as I've set out in some previous emails, there's no evidence that has been verified by the city that there is a noise issue at any of the adjoining residential properties. We've received this email yesterday raising concern. There isn't any specific detail that we can verify the concerns. They're general concerns. The process that we would follow from a customer service and a health noise compliance perspective would be identical if council deferred this application or approved it. I think so. We would go through the same process I set out before with the resident. We'd speak with the business operator if the concerns were being raised in relation to them, which they are at the moment. The management plan condition that has now been included in the recommendation would allow us to work and have some powers through the planning system to require the operator to address noise issues through the management of the premises. I think the one thing that is removed by not deferring the item is the ability to refuse this time period. However, council does have an obligation to make a decision on its merits. At this time, the applicant would have the right to have the matter reviewed by the SAT if it was deferred tonight, the same as if it was approved and this condition was a concern for them as well. So hopefully that answers your question.
Thank you, Director. Do councillors wish to ask any further questions or comment? Councillor Castle.
Through you, Mayor, question for the Director of Development Services. If we go through this process, if Council approves this application and then you investigate this complaint, perhaps receive other complaints from residents, and as a result of that, the owner of the business is either unwilling or unable to mitigate these noise problems, assuming that they breach the regulations, what would then be the consequence of the approval for the owner? What would be our next steps if that process isn't able to have a successful outcome for the resident?
Yes, through you, Mayor Cole, the requirements under the noise regulations would continue to apply, whether this approval is issued or not. The city would take action under the noise regulations and would continue to take action until the premises was brought into compliance. Ultimately, we would end up in court, and the court would make a decision around penalties, and that would continue until the premises was brought into compliance. So that's the process, and we've been in that situation before at the city, and ultimately applicants, operators of businesses, developers bring properties into compliance because that action is very costly, and provided we gather the evidence necessary to prove that that premises is causing the noise, then which would be a requirement to make a planning decision to refuse the application also, properties bring themselves into compliance because that process is not it's not a simple process for anyone.
Councillors, any further comments? Look, I will comment just to say that there have been a number of issues raised through this process, some of which are relevant to the planning determination before us and some which are not. There does seem to be considerable talk amongst tenants about damage to the structure of the building, yet the strata hasn't been able to, at this point, pull together to have a structural engineering report done, which is something that, unless the building is crumbling and causing an emergency situation and a risk to public safety, the city is not able to intervene. I do understand from speaking to the director that there has been some look at the cracks from the outside from a structural engineer from the city's building surveyor, my apologies, and that they have given some preliminary advice to the city that in the terms of the fact that this is not of a case where the city needs to intervene. So in terms of the emails that we've been receiving around structural damage to the building, in the absence of the strata actually coming together and dealing with those issues, it's very difficult for us to take that into consideration because we haven't had a structural engineering report provided through the strata. So that's been one of the difficulties with that communication from neighbouring tenancies. We are dealing with the 9 p.m. to 6 a.m. We are dealing with a situation where we have had our City of Vincent has gone out and measured the noise and has found that it meets the noise regulations. There is the issue of the new complaint from a residential neighbour, which has not yet been investigated, and we have two options before us to approve or to defer. And I think what the director's saying is that there's a pathway to deal with that noise complaint regardless. And in terms of some of the comments that we've heard today from the applicant in terms of some of the further attenuation that they may do, I would suggest that would be helpful to see that put in place, but obviously we can't condition and require that given that the noise regulations are being met. So we have had a number of issues come up and put to us, but I think that we do need to look at this very specific matter that we're dealing with tonight, which is the 9 p.m. to 6 a.m. operation of the gym on an ongoing basis. So if there are no further comments, I'll put the motion. All those in favour of the motion? I declare it carried unanimously. So we'll now go back to the beginning of the agenda and work our way through. 9.1, adoption of the fencing amendment, Local Law 2017, an absolute majority decision required. Do I have a mover and seconder for this item, please? Moved Councillor Castle, seconded Councillor Hallett. Councillor Castle, do you wish to speak to the item? Councillor Hallett, any comments or questions? Okay, I'll put the item. All those in favour? I declare it carried unanimously. Item 9.2, number 2 of 17 Green Street, Mount Hawthorn, change of use from shop to unlisted use. Another absolute majority decision required. Do I have a mover for this item? Councillor Loden, seconded Councillor Fotakis. Councillor Loden.
Thank you, Mayor. I'm supportive of the proposed development. I do have an amendment, but I did want to ask a question first, if I could, through to the Director. Previously, we've had proposals like this come up that have typically been operating for about 12 months and then they come back again and we approve them. This is slightly different because we've approved it under delegated authority twice, and now it's a different use, so we haven't undertaken the compliance steps that are normally taken. Given there's not been any complaints, why would them operating for another 12 months and then us approving it versus just enforcing compliance? I assume we can enforce compliance whether there's a pending approval or not. What would be the difference of having this potentially coming back in 12 months' time, hanging over their head?
Yes, through you, Mayor Cole, that's correct. Again, the action the city would take would be identical in either instance. The only difference would be they wouldn't have any approval if the 12-month condition was imposed and there were significant issues that would warrant a refusal. The reason the condition's been applied is simply because we haven't gone through those steps as you described, and the city's policy requires that condition to be applied in that circumstance for this type of consulting room. So that's the only reason.
So, given that feedback, I guess my view is this has already operated in this fashion for 2 years. We've had 2 years' worth of observing it and not having any complaints raised. I am highly confident that in 12 months' time we won't have any further complaints that are raised either, which would be a potential reason for refusal. So, I'll move the amendment, sorry, if I can get a seconder.
Do I have a seconder? Councillor Hallett.
Yeah, so basically, I think I've already covered my bases on this one. Yeah.
Councillor Hallett, do you wish to speak to the amendment? Does anyone wish to speak to the amendment?
Yes, I'll speak to the amendment, and I won't be supporting it. I'm really familiar with this building. I'm really familiar with this site. I'm not sure, and I would like to ask the question about the applicant, about whether the applicant has run any other businesses on this site or elsewhere in the city. I'm happy to deal with that in the substantive if you don't have the information with you at the moment. We've got a number of consulting rooms for massage around the city. Some, in my personal view, some seem to work quite well. Others don't. I know a number have closed down, even including one on Oxford Street. I'm surprised to hear there are no complaints, but I think that's a really good sign. I don't think it hurts to have another 12-month approval in place for this type of business. If the business is running fine and there's no complaints and it's all fine, then we won't get any other complaints. But my observations, and in some of the issues that I've raised as a councillor, both on this council and through inquiries through to the administration, there has not been a good track record, including on this particular site, one door down. Not saying that that's related in any way. To be honest, I'm very dubious about some of the businesses like this that operate. So I'm going to stay fairly consistent with how I voted on some of these matters before, and I'm not supportive of an ongoing approval, and think that would be happy to see them come back in 12 months' time. And if everything's fine, then at that time, I'd be happy to move an amendment for a longer approval. Yep.
Thank you. Any further comments on the amendment? Councillor Gontaszewski.
Thank you, Mayor. I just have a question through you to the Director of Development Services in relation to if a 12-month approval was conditioned in this instance, what is the city's role? You sort of talked about that we hadn't gone through the steps in this instance. I'm curious as to what the steps are. And then I guess my second question is in relation to just if you could just go through what the burden would be in relation to bringing back on the applicant in relation to bringing back another application in 12 months.
Yes, through you, Mayor Cole. I'm not sure I mentioned the steps, but I think Councillor Loden mentioned that. But we certainly haven't done an inspection of the property and a detailed inspection of the property during this time. Now, that's not something that we typically have done historically, but it is something that we are now looking to do where we have time-limited approvals that have been put in place for a particular purpose. So I think the concern and the reason why it was recommended was because the policy makes it very clear that 12-month approval should be issued in every instance. And we, despite not receiving any complaints, given the adjoining properties were commercial and there weren't nearby residents, we considered that there wasn't enough evidence to suggest that the issues that the policy has required that 12-month condition for had been addressed. In relation to the impact on the applicant, they will need to lodge an application fairly swiftly within the next few months or so, or next 6 months, to try and ensure they have an approval before this one expires. That simply involves a payment of a few $100s for their application to amend the approval. They won't need to do any more than that unless there are issues raised either by the city as a result of its inspections or by any complaints that come up in that period. But that's the extent of their obligation.
Thank you. Question to the Director of Development Services. In the event that during the next 12 months, regardless of what happens with this proposed amendment, the city inspects on site, what's the difference between the compliance action the city would take or what would be required in 12 months to... if there's a complaint, I assume we would act on it if there was a complaint regardless. So I'm trying to picture myself as a neighbour, having had 4 lots of advertising about this same premises over a 48-month period, and what that intimates to them, plus I suppose the administrative. But while it's only effectively a few $100s for the applicant, there is the process of filling in forms. If they're not the owner of the premises, they have to, through their agent, likely seek signing of Form 1s, etc. So there are some non-monetary impacts, both for the city and for the neighbours and for the applicant. I'm just curious as to if we believe that it's operating as it should, if we inspect, there'd be... So I'll ask it as a question. If we undertake an inspection and it's not as it should be, we have compliance action available to us. If we receive complaints, we have to act on it anyway. So what's the actual benefit of the 12-month approval if the intent is to inspect?
Through you, Mayor Cole, as I said earlier in response to Councillor Loden's question, there's no difference in the compliance action the city would take. The only difference is that ultimately the application that comes in at the end of that 12-month period may be refused on the basis of the operation of the business, or it may change because the operation of the business is not what is currently being proposed. I'm confident that won't occur because we have gone into a great amount of detail with the applicant to understand what they are actually proposing as part of this development for the first time since this development was approved or proposed. So we actually have an understanding of what's happening there now, and we're comfortable it meets the definition of massage premises under the city's policy. And that was the reason why the condition was imposed, because the policy states that the 12-month condition will be imposed in every instance for this type of premises.
Councillors? Look, I do have some sympathy for the applicant, given that when I asked at the briefing whether they were given a planning approval as originally as an AA consulting room, that was not necessarily their fault, because we have seen a few of these applications come through where we are correcting the interpretation of the change of use made at the time, which is, good to see, and we should be doing that. So I do agree that we should stick to the policy where these are new businesses, give 12 months, but I think given that they were first given approval in July 2015 for 12 months, they were then given a second approval. This will be their third. So it does start to become an impost on a small business, and I think that it's not entirely their fault that they have been put into this situation where they're now on their third DA, and that if we don't support the amendment, it will effectively be a fourth DA. I do start to think, does that, pass the pub test, and is this a bureaucracy gone mad story being created here? I think that the fact that they've provided a lot more information about what their business is now doing, and that they've had to do that through the application process, and that if there are issues we can still go in and deal with the compliance matters, I don't feel that there's grounds for a further 12-month period, so I will support the amendment. Any further comments? Okay. Councillor Fotakis.
Through you, Mayor Coles, just a question for Director of Development Services. Just with regards to the applicant, are they the owner of the property?
Through you, Mayor Cole, not that I'm aware. I'd have to confirm that. I'm not sure if the owner is the applicant. It's certainly an individual is the applicant. The owner is a company. So.
I will be supporting the amendment. My concern is with these short leases when it comes to being, abiding by the Commercial Properties, the Commercial Tenancies Act. I see a lot of these short leases. I see them as an impost on businesses, and particularly those that are proven, so I will be supporting the amendment.
Councillor Gondaszewski.
Just one more question. Just to confirm, if the Director of Development Services, if this amendment is approved, is the City's intention still to inspect the property at some point to provide a site visit to confirm some of those discussions that have already been had in relation to the compliance, or will that only occur on receipt of a complaint?
It's through Mayor Cole. If the conditions warrant it, we will inspect. If we get a complaint, we'll inspect. That's the approach that we're now looking to take. If the 12-month condition isn't on there, I'd have to sit down and have a look at the conditions to work out whether there'd be anything warranting an inspection. It doesn't look like that those conditions would warrant any inspection in this case. We can still do that based on this conversation and the concerns in the room. There's no reason why we can't go out and inspect. So given this long-winded conversation, and honestly, there's a lot of concern.
Director,
so
I think comprehensive is the word. Thank you.
We can definitely inspect the property. We should do that when these issues are raised and when there's concern in the room. So.
Would it assist if that was a condition of an approval?
No, that's not necessary.
Can we now bring this long-winded conversation to an end? Does anyone wish to add? Okay, I'll put the amendment. All those in favour of the amendment? All those against? Councillor Harley voting against. We're back to the substantive. Is there any further comment?
Thank you, Chair.
Yes?
I've got a number of questions. So I have a question in regards to the inspection regime for massage therapy centres, and while it's obviously an operational decision what businesses are inspected and at what intervals, I would like to know if there's any particular operational timeframes or expectations, particularly where we have 12-month limited approvals on premises.
Yes, through you, Mayor Cole. Historically, the City has not undertaken inspections in that circumstance, but as I've mentioned, it's something that I believe we should commence looking at, where there is a condition that warrants an inspection. we should be investigating those conditions to ensure they've been complied with, irrelevant of what it is. If it's a 12-month condition, that certainly warrants it in my view.
Thank you, and through you, Chair. Also, I think, look, I'm on the record as raising concerns about businesses that may be in operation. I'm not casting any shadow over this particular business, but I'm on the record as raising concerns about businesses that set up as massage therapy centres and essentially operate as brothels and use legal or illegal migrants and use unqualified people. And we have had a couple of them in the City of Vincent closed down, and no doubt there will be more. There is a proliferation of massage therapy centres, not just in WA but in other states in Australia. And if they're all offering massage, then there's a lot of very happy and relaxed people out there, I guess. But, you know, call me a cynic, but I just don't think that that is all the services that they operate. Again, not casting shadow over this particular business, but I do believe the city needs to be more diligent, and I've raised concerns also, and I'm raising it outside of the City of Vincent in some other forums in regards to the type of qualifications that massage therapists should have. And this is not obviously just in WA, but ultimately there are groups looking at whether there should be qualifications for massage therapists across Australia because of a potential linkage between massage therapy centres and illegal immigration and sex slavery. So that's my cards on the table, something I've been concerned about since I became a councillor. Before I became a councillor, it was something that prompted me to run for council, and I will remain. So, coming back to this application and understanding where my motivation is for some of the questions I ask, I would like to know, and if you could take it on notice and get back to us through you, Chair, to the Director, whether this applicant runs any other businesses in the City of Vincent.
Yes, through you, Mayor Cole. I'll need to take that on notice.
Yep, that would, I'll engage, depending on the answer to that, with administration separately on that. In regards to the street frontage and signage, etc., has there been, while there hasn't been an inspection of the premises, may I ask whether there's been a visual inspection of the premises any time in the last 2.5 years?
Yes, through you, Mayor Cole, as part of this application, the City did do a site visit, and the signage complies.
Great.
And the visibility between the inside of the front of the tenancy and the street has been maintained.
Okay, thank you. And one last question, and particularly for new councillors who may or may not be aware, are you able to go through the steps that the city has to go through in order to do an inspection of a property, either as just an operational inspection or where a complaint's been made? So, for example, if a complaint was made about a massage therapy centre offering sexual services, and I use this particular building because this particular building, one door down, we actually did close a massage therapy centre down, which was alleged to have been offering sexual services, and alleged to have potentially had the attention of the Immigration Department. So this was under a former mayor, former CEO, and largely a former group of councillors, but that's why this particular building is of interest to me. So are you able to run through the steps for councillors as to what we have to go through to enter that premises, the notice periods and things like that, so councillors can understand?
Through you, Mayor Cole, if we're entering the premises under the planning, under the city's scheme, then we have the right to do that at any time. If we're doing under the Local Government Act, we need to provide notice. If we suspect that if we have complaint around sexual services, then we would involve the police, and we would undertake those inspections together with the police jointly. So it really depends on the context of what's being investigated.
Councillor Hulley, do you have any further comments?
Not yet.
No, not at this point. Okay, is there any comments on this item? Okay, I'll put it. All those in favour? All those against? Councillor Hulley against. Thank you. Okay, moving to item 9.3, which is number 22 of 60 Smith Street, Highgate, change of use from group dwelling to unlisted use, bracket short-term dwelling. Another absolute majority decision. Do I have a mover for this item? Councillor Fotakis, and seconded Councillor Loden. Sorry.
I'm going to speak to this issue, but I've also got an amendment to propose as well. I am in support of, for a number of reasons, in support of this approval. I do acknowledge that the rise of Airbnb operations in key urban centres is a global phenomenon that most cities are not reacting well to. And this issue is a relatively new territory for our council and the community. There have been concerns that have been raised with council regarding the increase of unauthorised short-term rentals in Vincent. And notwithstanding those concerns that have been raised by a local resident, I'm pleased that this particular property owner has taken the necessary steps to obtain approval for a change in use. So can I speak to the amendment now, Mayor Cole?
I'll just see if we can have a seconder for the amendment, which is on the pink. Councillor Loden, thank you.
With this particular property, there are additional special considerations given the property is strata titled. So with the amendments, in addition to the management plan and the code of conduct being provided to the tenants, I've suggested that a copy of the scheme strata bylaws, particularly the Schedule 2 of the bylaws, is also provided. The reason why I've added that amendment is because for those not familiar with strata living, these bylaws cover issues such as behaviour of residents, children playing in the common property, laundry on the balconies, all of common complaints that are often given to stratas, and they're an important part of protecting all the owners and residents' rights to quiet enjoyment. So I see providing those as an advantage to the owner to minimise any prospective problems that may occur because of misunderstanding or of the tenants not understanding what their obligations are under the Strata Titles Act. Also understanding that this approval is not absolute. The comments from administration that the owner is required to ensure that he meets his obligations and other approvals such as those in the Strata Titles Act. So my concern was, as members of the Strata Company, all other owners, and I know the owner referred to 4 other lots within that Strata scheme. It's not just those adjoining lots that have an interest, it's all the other owners within that scheme have an interest whenever there's a change of use approved within a Strata scheme. So for that reason, I'm also asking that our approval be registered so that there's a full disclosure to any future buyers of this and other lots in the scheme moving forward, as a no surprises. So.
Thank you, Councillor Fotakis. Councillor Loden, do you wish to speak to the amendment?
Just a quick question. My interpretation from administration's comments is that they support the amendment. I just wanted to clarify if that was their view.
Yes, through you, Mayor Cole. That should have been included at the top of the comment. My apologies.
Councillor Hallett and then Councillor Castle.
Just a question through you, Mayor, to the Director of Development Services. Can you just comment on, I guess, the use of the advice note in terms of it not being enforceable and, I guess, the role for it?
Yes, through you, Mayor Cole. The advice notes are simply there to provide advice to applicants regarding their obligations under separate legislation, or if there are any other issues that they need to be made aware of, or to provide further details around how a condition may need to be met, or how the applicant can meet that condition. So they aren't enforceable. They're not part of the approval as a requirement of the approval. Given separate legislation governs these requirements, they're not required to be included as part of the approval and as part of the conditions.
Through you, Mayor, a question, well, I think a question for the Director of Development Services, but possibly also for Councillor Fotakis. I just want a bit of clarification on what 3.3 is designed to do. The management plan should be updated to include the strata bylaws applicable to the site. So does that simply mean that they should be provided to the other tenants, of which they would already have a copy? So it's really just to remind them that they have a role to play in this particular approval, because we also then talk in the advice note about obtaining approval. Obviously that's not enforceable by the city. And I wonder whether there's also another aspect to that which might include advising tenants of the short-term dwelling of the obligations under the strata bylaws to abide by those. So I just want to get a bit of clarification about who that's aimed at.
Yes, through you, Mayor Cole. The intent is it's aimed at the occupiers of the Airbnb or the short-term accommodation. So inclusion of the strata bylaws in the handbook and in the code of conduct for those people coming to stay at the site. So they are aware of all the strata bylaws because they will be obligated to comply with those, as well as all of the requirements that the city has imposed through the management plan.
So we're not, through this, requiring the owner of this property to advise the other strata owners of their intentions? Okay, thank you.
Councillor Hallett.
I may have missed it, but I just wanted to ask Director of Development Services through you, Mayor Cole, about the condition related to the minimum 3-night stay. I couldn't see a rationale for that within the comments of the report, and just wondered if you could outline why that was included.
We're still on the amendment at the moment, but we'll come back to that when we've finished with the amendment and we're back to the substantive, if that's okay, Councillor Hallett. Are there any further comments on the amendment on the pink before I put that? Okay, all those in favour? I declare it carried unanimously. Back to you, Councillor Hallett. We're back to substantive.
Do I need to repeat that? Or yep.
Through you, Mayor Cole, that was what the applicant has applied for. So they've applied for a minimum 3-night stay, and they've made that clear. That was what was advertised to the surrounding properties. So that's what their comments were based on, or their lack of comment was based on the fact that it was a minimum 3-night stay proposal.
Councillor Hallett, go ahead.
And just, I guess we've had some communication around this, and I'm supportive of the substantive motion, but some of the discussion's been around the tension between encouraging visitors and tourism to Vincent, and then also, I guess, the impact of some of the short-term accommodation on broader housing affordability and the availability of rental stock. I was just wondering if the Director had any comments around our housing affordability strategy, which is from 2008, and I guess since then any monitoring or revisiting of that has occurred, and perhaps whether the short-term accommodation discussions that have been mooted will be included in a review of that.
Through you, Mayor Cole, the short answer is no. We haven't done a review of the housing affordability in the city, and we haven't considered the impact that the anecdotal increase in short-term accommodation in the city is having on those factors. That's certainly something that the city can do as part of the review of the policy, but I think that will come out of the discussion we have with council members in the next month or so regarding the impact of LPS 2 and some of the issues that the city's facing, the various planning issues the city's facing, one of which is certainly short-term accommodation. So it may well be an important part of a broader review of that policy and the city's position on those issues.
Councillors, could I just make some general comments, because I know that we have been having a bit of a discussion about our current approach to short-term accommodation and our temporary accommodation policy, and the fact that we have received a number of complaints about unauthorised operations within the City of Vincent. We have flagged that our policy is not really responding to the likes of Airbnb, and that we do need to have further discussions between council and administration about reviewing that policy, particularly in light of local planning scheme 2 being on the doorstep of approval from the minister. So we've just certainly acknowledged that this is an issue that currently our existing policy doesn't really address and respond to well, as evidenced by the fact that I think there'd be a very poor awareness in the community for people running Airbnb that they would actually need a development approval, and that we have a number of different scales operating in terms of that Airbnb model, whereas it's, resident renting out a room or a full-scale operation of someone owning a number of units across the City of Vincent. So we have noted that this is a conversation that we wish to have with administration, and administration has acknowledged that that is something that is on the radar, and particularly now that our local planning scheme does take the addressing of short-term accommodation further than our very antiquated town planning scheme that we're still creaking along under, hopefully not for many more days. So I do support the application, but I do acknowledge that a broader conversation and a revision of our policy does need to happen. I'll put the motion. All those in favour? I declare it carried unanimously. That concludes the development services items for this evening. Thank you, Director. Moving on to engineering, item 10.1, Safe Active Streets Bike Boulevard Progress Report 4. Do I have a mover for this item? Moved Councillor Loden, seconded Councillor Toppelberg.
Thank you, Mayor. I'm supportive of this program. It's very clear that there's strong community support for this initiative. It's going to have a lot of benefit through this community, through this section of our streets, and provide that continuity from the existing previously bike boulevard, now Safe Active Streets. There has been some work done to address the parking issues that are being removed on Richmond Street, which means that we're able to retain them, as well as 2 Acrod bays, which is also great. I did have a question for the Director, although I think it's associated with the amendment. So I'll move the amendment if I can get a seconder.
Can I have a seconder for the orange? Councillor Hallett, thank you.
Thank you. So I've had some discussions with administration about this over the last couple of days, particularly around the issue of retaining the parking, which has been achieved. And you can see with the proposed amendment here, and the increasing planting along that street, which was part of the feedback that came from the community to help with the beautification of the streetscape. My question, however, is around this point around planting of additional street trees. Will that also include planting of those trees in the nibs that are being installed as well?
Through you, Mayor Cole, that's correct. There will be some trees planted in the nibs too.
So I'd like to recommend this amendment. It will increase the number of trees along the streetscape and is ensuring that we are retaining those parking bays near the kindergarten and the TAFE, as well as the 2 Acrod bays. Thank you.
Councillor Toppelberg, you were the seconder. Do you wish to speak? Oh no, Councillor Hallett, sorry, you were the seconder to the amendment. No? No further comment? Any comments in relation to the amendment? Look, I just would let's add that I think this is fantastic that the Director has responded to the issues raised about parking and re-looked at the design during the week and managed to secure that parking, because I think that is one of the comments that came through the community consultation that people are really concerned about, and I think it's great to be able to say that we were able to revisit and save that car parking, particularly with the Acrod bays and the proximity to Margaret's kindergarten. I know it's extremely well used, and always love additional street trees, so this is a great result, and happy to support the amendment. I'll put the amendment. All those in favour? Declare it carried unanimously. We're back to the substantive. Are there any further comments? Councillor Toppelberg, did you wish to speak as a seconder? Okay, I'll put it. All those in favour? Declare the motion carried unanimously.
Mayor Cole, may I move a procedural motion that we change the order and deal with item 13.3? I believe we have someone in the gallery who's awaiting the discussion of the late item which relates to the annual general meeting and the motion that she put up at that meeting.
Just let me... That was actually moved on block, that item. So, Mari, just to let you know, if you are waiting for item 13.3, which is the late item on the annual general meeting of electors, that item was moved on block by council. So you're very welcome to stay. I just wanted to let you know. Thank you. Okay, so the next item, if we're dealing with them sequentially, is 11.3, adoption of the Standing Orders Amendment Local Law 2017. I believe this was raised by you, Councillor Toppelberg. You happy to move?
Yeah, I'll move it.
And the seconder, please. Councillor Gonchevsky.
So I'll begin with an apology, and there's a bit of irony in this as well. So there was some, it was raised last week at the briefing, but there was some discussion in relation to clause 7, which deals with motions of deferral, which is a procedural motion. And when I say I'll begin with an apology, I should have had this sorted out before last week, and the irony that's attached to it is that what I'm about to do is actually the intent of the motion anyway. Which is that I will foreshadow deferral of this so that we can deal with it. And so, effectively, currently under the system, as when a procedural motion is moved, the presiding member is required to call for a seconder for that motion. The tradition in this chamber has been to say there's no debate on procedural motions, but if you actually look at the standing orders, the mover of that motion actually has 5 minutes to speak on it in the case of a deferral. But the issue the issue is that on occasion there are elected members who wish to speak to an item, but somebody who speaks before them seeks to move a deferral, and sometimes it's the first person to speak. And in the event that that's supported, and particularly with contentious issues, perhaps there are matters that either elected members wish to raise, or personally I find also that in the event that people take the time to actually attend the meeting and want to listen to debate on the item or to understand some of the issues, they're denied that opportunity because it gets deferred before people have opportunity to speak. So I did try, just prior to the meeting, with the Manager of Governance and Risk to actually come up with a solution, but we weren't able to. So in the spirit of that, I will allow others to speak, but we'll foreshadow deferral of the item to the next meeting such that we can actually amend that clause. So it relates to clause 7 within the standing orders. And again, I do apologise. Under our current system, I should be able to have such matters resolved prior to the meeting, but I do think it's important and don't want to go through the process of having to amend the local law again.
Through you, Mayor Cole, apologies, I wasn't privy to the conversation that occurred earlier between Councillor Toppelberg and our Manager Governance and Risk. It would just be worthwhile, Mayor Cole, through you, if Councillor Toppelberg could just identify specifically where the changes might be incorporated into the amendment local law to address the particular issue at hand.
Yep, so I'll tell you exactly, just one moment. So clause 7, 7 deals with procedural motions. Sorry, I'm just flicking through to it. So 6.1 deals with permissible procedural motions. Currently, so clause 7.1, that the motion be deferred. The effect of the motion, if carried, causes all debate on the substantive motion or any amendment to cease, and for the motion to be deferred and resubmitted for consideration at a subsequent time or date specified in the motion. And it says that a member may, at the conclusion of the speech of any other member, move without notice that the motion of any part or any part of it be deferred and referred back for further consideration. And it then goes on to discuss how that would happen. We were just struggling on the fly to come up with wording that would enable, effectively, the intent would be for the presiding member to be able to seek for other members who wish to speak before calling for a seconder for that motion, but that's got issues in relation to other parts of the standing orders, so the actual wording of it needs to be dealt with. So I apologise again, but it's to do with clauses 2 and 3 and how they fit in terms of... But the intent is for where elected members wish to speak on a motion, even though it's intended to be deferred, that opportunity is afforded to them.
So just to clarify, effectively, you'd be looking at amendment to 4C, 7.14C, where it says, on a motion referred to in subclause 3, which is that the motion be deferred, the mover shall not speak for more than 5 minutes, the seconder shall not speak other than to formally second, okay, so it would need to be amendment to that, and also to C, no other debate shall be allowed.
I'm not sure. We'd have to test it, because once the motion has been moved, you have to call for a seconder, and once that's done, the effect of a procedural motion is it needs to be voted on. So we do have to. That's why it does. But it's within that procedure, yes. But the current practice is, as I've done in this debate, to foreshadow the intent to move the deferral. If that's not done and someone seeks to move it via the standing orders, we need to be able to find a way to prevent that happening if other members wish to speak.
I just want to ask a question of the CEO. Is there anything currently here that would preclude a council member foreshadowing a deferral but stating that they wish to allow council members to speak to the motion before they actually proceed to move a deferral motion?
Through you, Mayor Cole, in short, no, there's nothing in the standing orders that allows what is effectively a meeting courtesy to occur, such that one councillor, in this particular instance, Councillor Toppelberg, has identified an issue worthy of discussion and debate on the matter at hand, but that he is just alerting other council members to the prospect of wanting to defer a procedural motion, but only once everyone else has had the opportunity to speak to it. So, no, the standing orders don't interfere with that.
As the presiding member, if a council member wishes to indicate that they will move a deferral towards the end of the debate, I don't have a problem with that. I'm not sure if that satisfies what it is that you're...
Just for clarity, if I move a deferral, and if, for example, Councillor Hallett wants to speak under the standing orders, you're obligated to call for a seconder, and that deferral motion, so depending on the nature of the debate, there may be 5 and 4 people who wish to defer or otherwise, and it would not afford him the opportunity. So whilst the courtesy remains currently, there are circumstances where you can preclude others from speaking.
I can see what you're saying, because no one gets the opportunity to say, we wish to speak first and defer later. I get that. Okay. Councillor Harley, do you wish to speak to this?
Can I move a deferral motion? I've got a question, and this is where a deferral would be useful, but for the sake of courtesy, I'll let everyone else have their say. We need to discuss this, and so I'd be very happy, in fact, for this to come back for even a workshop, because it's about discussions about the purpose of the debate, the purpose of what it is we're doing here, and the purpose of where a deferral is clearly imminent, particularly where the first speaker indicates they're going to defer anyway, so it's coming back. That may be what people wish to do and have a very good reason for doing that, but I think we need to talk about it, because if there's 8 of us who are just going to keep speaking where we know the first speaker's they've already foreshadowed, I personally find that a bit off-putting, where I know somebody's just going to come in and move a deferral anyway, therefore there is no decision that we are going to be making about the item. I actually question why we would spend that amount of time personally doing that. So I don't know what to do now, because I'd be happy to see the matter deferred for another time, and I'll foreshadow a deferral motion and see who else wants to have a say.
Before you do so, the CEO does wish to provide some further information.
Thank you, Mayor Cole. Sorry, I may have earlier misinterpreted your question as what was happening here and now in terms of Councillor Toppelberg's foreshadowing of a deferral, not the effect of what was being proposed. But as an extension to the point that Councillor Harley's just raised, I think it's just worth noting that if the first, or if one of the earlier speaking council members were to move a deferral motion, then the balance of council has the obvious right to decide to vote either in favour of that deferral or not in favour of that deferral. If the majority of councillors did not agree to vote in favour of that procedural motion to defer, it would be lost and you would resume discussion and debate on the matter. So that is, by simple voting, the ability that council has to either allow or disallow a deferral in that particular case. The problem is more acute, though, if the majority of council members have already had their chance to speak on an issue, leaving only the minority of council, in this case, if we have a full house of 4 council members remaining, who would then be denied the opportunity to speak on the substantive issue, because even if they voted against the procedural motion, it would still succeed because the majority who have already spoken may presumably then vote in favour of the procedural motion. But just worth noting that the vote also counts. The procedural motion is not automatic just because it's been moved and seconded.
Councillors? Councillor Castle?
I would just raise through you, Mayor, on this point that a question. We're discussing here whether, if a deferral motion is foreshadowed, whether there should be debate on the substantive motion. Is there any benefit to discussing whether any debate should be allowed on the deferral motion? And obviously, a lot of these procedures are in place to keep the meeting flowing and not getting bogged down in endless debate. But I wonder if there might be situations where that could be appropriate. For example, the foreshadowed deferral motion from a previous item, if that had been put and if debate had been allowed, I would have had some questions for administration, but they wouldn't have been able to be put under the current standing order. So if we are going to have a discussion about how we manage our deferral motions, is it worth also throwing that into the mix to see if that's something that we would want to do or not?
Through you, Mayor Cole, the only point of clarification I would add is that the suggestion that's been made in relation to the procedural motion to defer at clause 7.1 of the current standing orders is not about foreshadowing. It's about a member actually enacting that clause and moving and then getting a seconder for that procedural motion, because then you're right, Councillor Castle, what you said using that earlier example is if that were to occur, you would be denied the opportunity to speak on the substantive issue, because the procedural motion under this clause has the effect of intercepting all other discussion and debate on the substantive item, and only the procedural motion can then be determined. If it's carried, then that's the end of that discussion at that particular meeting.
I guess my question is, should there be any debate on the procedural motion?
Through you, Mayor Cole, I think perhaps that's one of the points that Councillor Toppelberg was talking to, and what administration is happy to take guidance and instruction from Council on. I'd probably also just highlight that there are a number of other procedural motions that are available to any council member, and if administration were to go away and consider this issue in more detail, we would need to have regard to those other potential overlapping options that could also be then introduced to a procedural motion. So you would then have a motion upon a motion upon a motion, such that if a council member were then to move in accordance with clause 7.4 of the current standing orders, that, look, this discussion on the procedural motion, if debate were allowed, has gone on for 25 minutes so far, and that's each 5 council members exhausting their 5-minute allocation to speak on the motion, if that were the case, then they were to move that the motion now be put, then you're dealing with, do we or do we not just put the procedural motion? So then it opens the door to this kind of conversation again. But as I said, there's really no right or wrong. Administration is very happy to take instruction and direction from council member or council on what your preference might be for how your own meeting is run. If that can't quickly and easily be sorted out through crafting some changes to the clauses on the run, then my preference would be that we go away, we look at all of the options that exist, and then we bring those back to council members to consider in more detail.
Through you, Chair, may I ask a question? If you lift that rock, open the Pandora's box, whatever terminology you'd like, there's obviously some others that I'm asking whether you need to look at, because if I've understood the spirit of how this is intended, it's about allowing debate, allowing councillors to have their views heard, and not, I guess, closing down debate where it's clear other people want to have a say. For whatever reason, they want to have their say on that night, even though there's been a foreshadow of a deferral, and it will be coming back to at least 2 more meetings. So I specifically refer you to the section in regards to I move the motion be put. That could close debate down at any time. That would have implications, and also the general standing orders that a presiding officer can use, which is where they can decide whether there's any further speakers at all after we've had, speaker for, speaker against, etc. Those are actually, in my view, mechanisms which could close down debate, really close down debate, and be used by both the presiding officer and councillors to intervene at a point where a debate, could be heating up, to actually close down debate. I beg your pardon? Yeah, so my question is, thank you, Josh. It's always good to be skilled by you in this. Will you also be looking at those and any other intersecting standing orders?
Through you, Mayor Cole, I would most likely, administration would most likely just confine our attention to whatever it is that that council members have flagged needs particular exploration. There's a couple of reasons for that. Firstly, because the amendment local law has been advertised. In keeping with our legislative obligations under the Local Government Act, we have to ensure that we stay true to the designated purpose and effect of the local law, which appears on page 336 of the amendment of the agenda papers. And notably, the first line of the purpose says that the purpose of the amendment local law is to make a number of minor amendments to the principal City of Vincent Standing Orders local law. That being the case, I think it would be open for someone quite easily to argue that if we start to reconstruct and re-examine a whole raft of other provisions of the local law that weren't included in the amendment local law, that could then begin to stray into being more than just minor modifications or minor amendments. In this particular instance, I think we could quite successfully mount the case to say that it's still in keeping with a reconstruction around clause 7.1 dealing with the procedural motion to defer, to introduce some debate or all debate on that kind of procedural motion, or to loosen it up so that there is more council member ability to get involved in the substantive or the procedural discussion. I believe that that would still stay true to the purpose and effect of the advertised amendment local law, and therefore would not require us to revisit and restart the cycle from the outset, which is what will otherwise need to happen. So we just need to be mindful of the fact that that legislative requirement exists. Having said all of that, and sorry, not meaning to bore you, but just as a note also that under the local...
Move a deferral motion now.
You can, and I'll just stop speaking. But in the absence of that, through you, Mayor Cole, the Local Government Act doesn't stipulate a time frame within which council needs to make a decision on this matter after the conclusion of the public advertising period. So it's not time critical at this point in the process. If council wanted to defer it so that we can go away and do some more work and come back to you on that, then that does not in any way fetter our compliance with the Act.
Councillors?
Wanted to throw in something just quickly. Just a question to you, presiding officer, if you had any desire to want to move motions at all in the standing orders.
I think that is quite a significant issue. We did discuss moving amendments, and I just think that because we're at the stage we're at, that it's been advertised, we've had the discussion, we've had the opportunity to provide comment, we've advertised the draft local law. I think that is quite a big ticket item to start providing the presiding member with the ability to move amendments. I also don't particularly feel strongly about this 7.1. I think that it's not a major issue, and I am conscious of the fact that this has been advertised. But if there is a strong will of council to defer and have further discussion, that's fine. But I personally don't feel that this is something that's constraining council, that when something is deferred it will come back to council. So it's not that you're actually being prohibited from speaking on a matter. It's about saying, well, we're not actually making a decision today, we're not dealing with it, so therefore it's being deferred, it's going to come back to council. Sometimes I think that if you've made a decision to defer, that you should just act and then just move on. And otherwise, if it's endless communication about debating a motion, other matters come up, and it can just become quite a conversation. And if there is a will to defer, maybe just be clear and move on. So, but on your question, Councillor Murphy, I think that we've come too far with advertising, and to start providing the presiding member with the ability to move motions and amendments, that is quite a significant change, and I'd feel uncomfortable making that change without that having been advertised. Any further comments or questions? Councillor Gontaszewski.
I just thought I would add my voice to this comprehensive discussion. I think that, from my point of view, I feel that I have discussed this, and this has come before us in a number of forums previously, and it's gone out for consultation. However, I think that it is all in the crafting. So I feel that should a deferral be moved, I would be supportive of that. However, I would, yes, definitely prefer that its scope be quite restricted at this time, noting, of course, that that doesn't preclude, I guess, further reviews and discussion and debate, going forward, if that is the will of council.
Thank you, Councillor Gontaszewski. Councillor Hallett.
I think there are only a couple more after this. I guess I would support deferral, mostly for the reason of having people in the public gallery who we've deferred things previously that have sometimes already taken quite a substantial amount of time, and people are waiting for some kind of a resolution, and for them to have at least some level of update at that time of a deferral might be quite useful, rather than them just having to sit on it for another month. So,
councillors, as you know, I cannot move any motion, so.
But I get a right of reply.
Yes.
So
we're going to a right of reply.
Yep. So I just wanted to note that this isn't about a fairness principle of letting everyone yap on about stuff unnecessarily. But in this chamber, on numerous occasions, I've sat here where circumstances are either misunderstood, or there's been an alternative view of somebody who, or a potential slim majority of council, who have had a desire to defer something, and yet some of the issues that they held may have been resolved through debate. So where people don't understand or take a particular view on an aspect, particularly with development applications. And so it's not just a fairness principle for me about allowing people to speak because they want to speak or be heard when they're going to speak again. It's about ensuring that we get good quality decision making, and that where resolution can be attained in the chamber at the time, and perhaps deferral is not the best idea, if we only hear from one person potentially and we potentially go to deferral, especially where issues are contentious or there are matters that are simply resolvable either through questions or contribution to debate, or because there's people in the gallery who've given up their time or invested their time to come and hear and participate, that isn't denied to them by the actions of one elected member. And currently there's no facility for that other than for the presiding officer. Well, there are provisions for it, but they are unusual. So for me it's quite simple, and to that end I shall move to defer this item.
Councillor Tubbleberg, I just have to seek advice on whether you can actually move a deferral at this point. You might have just shot yourself in the foot.
You can at any time.
Through you, Mayor Cole, that's a very good point, and I don't think it's clear cut. So if you'll just bear with me for one moment.
So, unlike the motion to be adjourned, which precludes someone who's already spoken from moving it, there's nothing that precludes a person from while they're speaking or otherwise. It says at the conclusion of a speech, but it says it may move without notice that the motion or any part of it be deferred. And I would say in the absence of clause 7.26 appearing in section 7.1, it implies that the person who is speaking is able to move it at any time.
Just to explain, because Councillor Toppelberg was the mover of this item, he's opted to use his right of reply, which concludes debate. So we're just making absolutely certain that you can move a deferral during right of reply. And I'm happy to be as flexible as the standing orders allow.
Through you, Mayor Cole, just in conferring with the Manager Governance and Risk, the effective clause of the standing orders is actually clause 4.13 bracket D, which says once the right of reply has been taken, which it was in this case, there can be no further discussion nor any other amendment, and the original motion or the original motion as amended is immediately to be put to the vote.
It's not really clarifying procedural motions, is it? It's about amendments.
Yes, that's right, Mayor Cole. So the issue there is that once the right of reply has been taken, no further discussion, you could effectively treat that as an end there. No further discussion, full stop, which was the case, nor any other amendment. You could treat that separately, and the original motion or the original motion as amended is immediately to be put to the vote. Having said all of that, given that there is actually some active conflict between the elements of the procedural motion, which if you read those in isolation of clause 4.13, then you could have the reverse view. But I think, not being cute about the wording, but given that clause 4.13D doesn't specifically prohibit a procedural motion, I think under the circumstances it could be open to you, Mayor Cole, to accept it.
I will allow a procedural motion because I think this also highlights that we have some further investigation. So, Councillor Toppelberg, over to you.
So simply that, so the item be deferred to enable further discussion in relation to the effect of procedural motions, Part 7 in the standing orders.
Seconded by Councillor Gondaszewski. All those in favour of the deferral motion? All those against? Declare it carried with Councillor Harley voting against. We're now at item 11.5, variation of lease to include additional artists as joint lessees at Helverson Hall, Robertson Park. I believe this was raised by Councillor... Was it raised by Councillor Murphy? Councillor Hallett? Oh, it doesn't matter. What's it? You raised it, Councillor Hallett? Would you like to move? We'll move.
Yes, I'll move.
Yeah, okay. Councillor Hallett seconded. Also, take Councillor Murphy, seeing he's put his hand up first. Thanks.
Yes.
You're seconding. Just to be clear, that was a bit confused. Next time we'll just take whoever puts their hand up first. Go ahead, Councillor Hallett.
I support the officer recommendation and we'll hand over to the seconder to comment further.
Perfect. Thank you, Councillor Murphy.
No, look, I was just going to support the changes and support the motion.
Councillor Loden, do you wish to speak? Okay. I'm so glad that we raised that item. All those in favour? Declare it carried unanimously. Over to 11.6, which requires an absolute majority decision, amendment to terms of reference, Audit Committee and Safer Vincent Crime Prevention Partnership. Do I have a mover for this item? Move Councillor Loden, seconded Councillor Gondaszewski.
I'm happy to support the item.
Thank you, Councillor Loden. Councillor Kondrashevsky?
No further comments from me.
Councillors? Okay, I'll put the motion. All those in favour? Declare it carried unanimously. I note we haven't asked the Director of Corporate Services a single question tonight, but there is still time. We're now moving to item 13.1, which is the information bulletin. To have a mover for this item, Councillor Loden, seconded Councillor Kondrashevsky.
Thank you, Mayor. In the interest of time, I'll just go straight to the proposed amendment, if I can get a seconder.
Councillor Kondrashevsky, do you wish to second the amendment, or anyone else?
Yes, am I able to request that the amendment be considered in two parts?
Yes, that's possible, yes. If the mover... Well, actually, yes, I can grant that, yes.
Thank you. I guess this amendment came about because the minutes of the Mandara Regional Council meeting showed that they have a... Sorry, 1 second. $1.17 million budget deficit due to decreased waste flows to the Mandara Regional to Marla Park, and a decision was made, which I note that the Mayor and a number of other councillors voted against, to specifically fund participation in a conference for councillors in rural Victoria to better understand waste management at a cost of $42,000 of unbudgeted expense. In addition, in that same meeting, a decision was made to defer a decision on the energy from waste proposal, and to my understanding there is no intent to go back and revisit this. So I guess I would like to reaffirm the position the Mayor put, that we are opposed to this expenditure. It's inappropriate in this context. And secondly, to request that the Chief Executive Officer write to the MRC seeking confirmation of who will be attending that conference. I recognise that we can't change it because the conference is in about 2 weeks' time, but I think it's important to remind them that this is on the public record, and I don't think it passes the pub test as a plausible expenditure.
Councillor Kondrashevsky.
Look, I'm supportive of the first part of the amendment, that's item 2 on the list, in relation to reaffirming the Mayor's opposition to the councillors attending this conference. However, I'm not supportive of item 3 in relation to requesting that the Chief Executive Officer write to the MRC. This feels like overstepping to me in relation to a decision on which we have a representative on the group who opposed what was eventually approved, but still took part in that process. I feel that essentially our minutes are publicly available. We are speaking on web streaming at this point in time, and so I feel that yes, whilst it is appropriate for us to discuss and debate the items that come before us in relation to this information bulletin, and potentially draw attention to elements of that that may, I guess, allow us to raise the priority of certain issues within that bulletin, and in this instance to certainly reaffirm that the Mayor who opposed this conference is supported by Council in her representation on that group. I don't feel that that writing a letter in relation to a decision that has already been taken, that the Mayor is part of, it feels somewhat like chastisement, and I just don't feel that it is our role to do that. I feel that we have access to potentially additional information through through briefing and council decision-making forums if we want to obtain additional information in relation to who's attending, etc. I'm sure that is can be made publicly available. I don't necessarily feel that we need to go forth and do that in a formal fashion through a letter to the MRC in this regard.
Councillors.
Through you, Chair. Is this? Were you at the meeting representing the City of Vincent? Was the decision made about who would attend the conference made at that meeting?
No. Would you like me to describe
Yes,
what happened
please.
at the meeting?
Thank
you. Basically, it was an item that I had flagged immediately upon reading the agenda, that this was, first of all, we were dealing with the energy from waste tender that evening, that this was unbudgeted expenditure, and that we're also looking at significant increases in the gate fee, and what has ended up happening at the most recent meeting is that we've actually had to delve into 1.8 million of a $2 million surplus to reduce the gate fee increase at mid-year review, which is still going up by $6, but we'll be looking at a $35 increase at next year's budget, and that's without reviewed forecasts coming in from all of the member councils. So for me it was a significant issue. When we got to the item, I asked for it to be, I moved a procedural motion for it to be deferred so that it would be considered at the end of the meeting after the confidential item, which was the energy from waste tender, thinking that that would be a queue, that if that process, that tender was not adopted, that we could, as a group, appreciate that to go to an energy from waste conference would not be necessary. And at the time that we got to this motion, I did argue vehemently against this. I put forward 3 key factors: that this was that we had just refused a energy from waste tender, which has been a long and ongoing and very well considered process from member councils, sort of came together on that in the end. Secondly, that we were facing significant revision, not only at mid-year review but in the next financial year in terms of gate fee. And thirdly, that this was unbudgeted expenditure, so that the perception would be really quite irksome in my view. I was supported by 2 council members who also spoke against it. Actually, I think only Councillor Jacobs spoke against it on a perception factor, and I think Councillor Norman didn't speak, but voted against. And at that stage also, just to mention that Council Member Shannon from Cambridge had left the meeting, so she wasn't actually in attendance. So I don't always like the outcomes of MRC, but I am a very vocal participant. I think the CEO and Director for Corporate Engineering can vouch for that, and I am not afraid to voice my opinion, and I made it extremely clearly at that meeting, so I was quite disappointed in the outcome.
Thank you, Mayor. Just another question. So the attendees were not chosen at that meeting. By what means are they going to choose those attendees?
It's open for all member councils to put themselves forward. In fact, I voted against it but received an email a couple of days later asking whether I wished to attend the conference, which I very politely declined. So it's unbudgeted expenditure up to $43,000 depending on how many council members take up that offer to attend that conference. So even those members who voted against it were invited to attend the conference.
Thank you, Mayor. I do think we should write a letter. I think that we need to... my personal opinion, obviously I wasn't at the meeting, but it doesn't sound great. It probably wouldn't look great for anyone out there in the wider audience who had a clue what an MRC was or what they did or how it may or may not impact on us as a city. But it raises a number of questions, and we are there because we represent the City of Vincent. There is money involved. There are substantial potential sums of money involved in tenders, what we do with our waste, long-term decisions which will affect residents and ratepayers of this city long after we're gone. And this, along the way, I think we do need to make our view known, because that's the only way we will change potentially change the behaviours further down the track when a similar motion like this comes before MRC. I listened to Councillor Gonchaszewski. I don't believe we're overstepping the mark. What we are asking for here is that that we be provided with confirmation of which council members will be attending the Interstate Energy from Waste Conference. I believe that's entirely appropriate for us to know who from the MRC and from which councils are attending, and including our own council representative. So I understand we're dealing with this in two parts, but I support both part 2 and part 3 of this, and I'm very interested to know which councillors are putting their hands up for this conference, and very interested to know whether their councils themselves are aware that their councillors may be going on this conference. So I think we push the envelope. We do what we've continued to do at the City of Vincent, and we make our views known about whether we think this is okay or not, albeit that you're a voting member. As a council, what's our view about this? And I think that we should make that view known, if the CEO is comfortable in doing so. If the CEO is not comfortable in doing so, then I would not feel minded to in any way form a direction out of this amendment. But the word here says requests, and I'm entirely comfortable with providing the CEO with the authorising environment to send a letter if he feels it's appropriate.
Through you, Mayor Cole, I suppose all I would say is that most wise CEOs would probably interpret a request from council as an instruction. If that's the measure, then I class myself as a wise CEO. If the request, or if the recommendation 3 is worded as is, then it will happen. I will write a letter to the MRC. The tone and style of that letter is going to be such that it's appropriate. I absolutely accept Councillor Gonchaszewski's point and concern, because I would not want it to come across as being insulting or condescending, or that City of Vincent Council or administration is somehow standing in judge of what is, in essence and at law, a separate entity entitled to act and make decisions of its own volition, independent of the origins of its members, and that is just a statement of fact. You will note in the administration comment we've advised that we have no objection to the proposed motion, and that's all parts of it, but noting that it has no material effect in altering the MRC's decision that has been made and the entitlement of MRC member councillors to nominate themselves to attend this particular conference. Through you, Mayor Cole, probably the last point I would simply just add, it was remiss of me to not include it in the administration comments, is that in a general sense, energy from waste will still be part of MRC's long-term waste strategy. If, how, when that is ever pursued is still something for Mayor Cole and other councillors at MRC to determine through that forum.
Councillors, Councillor Toppelberg.
Just a couple of things just to note. I guess my issue when I saw this amendment coming through is with the word reaffirms, in the sense that it's not, whilst we are entitled to a representative, we duly elect you to represent this council in that place, but we don't determine how you shall view matters, and that is still an individual choice in your role as a representative. And I guess the term reaffirms for me, that did jar with me, because it given the nature of what we're talking about, I have issue with that terminology. There have been things that I've disagreed with that have gone on in regional councils where elected members of the city have made decisions that I personally have disagreed with and would have done differently in that role. But I don't think it's for me to judge that either way, and I don't. Yeah, so I have some issue with that terminology. I don't know how to resolve it, but I'll leave that open for now, and maybe leave that up to the mover. But just in relation to part 3, regardless of how we end up in the room, we're a 1/12 contributor, and as any ratepayer has a right to come in here and ask questions, we have a right to ask where we're paying for 1/12 of this conference effectively. So I have no issue as however we come about, and I don't irrespective of the decision and how it was reached, we have an entitlement to that information. What we do with that information is then perhaps something different, but I think our entitlement to it is clear. And I did ask the question at last week's briefing in relation to the Urban Development Conference and the serial attendees from the Tamala Park Regional Council, and perhaps we may look forward to a presentation from the attending council members of the MRC who want to come and teach us all about energy from waste, and maybe give a presentation to the City of Vincent as what they've learned from the conference thereafter.
Thank you. Councillor Hallett.
Just a question, I guess, to either of you folks. Will the MRC members that attend the conference be publicly available regardless of us asking?
I believe the expenditure will, because it will basically have a each month every second month the council has to approve expenditure, but I'm not sure whether it will be a lump sum or whether it will be broken down in the way that our that when we have council member fees it's broken down by name. The tendency seems to be that less information is given in MRC reports than the standard that's set at the City of Vincent. So I'm not entirely sure, but in terms of the actual amount expended, then yes, that would be publicly available.
Through you, Mayor Cole, in addition to what the Mayor's just advised, it has been historically custom and habit at both regional councils that we're involved in, Tamala Park and Minoa Regional Council, that after attendance at a conference, the CEO or the relevant director that has attended will ordinarily present a very brief report for noting, either circulated to council members, but more ordinarily as a proper council report in the agenda papers. So my view is that the same would most likely occur in this instance if history is anything to go by, and on that basis reports of that nature in the past have stated that, and the conference was attended by Councillor X, Y and Z. So I think in addition to what the Mayor's advised about the costings, because the financial statements should then be traceable back to attendance by particular council members and staff. That being the case, yes, the information will eventually be discoverable.
And through that, there would be opportunity for me to ask a question at the MRC. So that's, that always remains an option as well, that I will have other opportunities to ask questions on attendance at the conference. Councillor Castle.
I think, through you, Mayor, I think the CEO's just answered one of my questions, which would be, what are we allowed to, what might we be allowed to request in terms of a report? Presumably MRC needs to see some benefit from sending delegates to this, and equally we do as well. But if you're saying there'll be a report through their meeting, then that potentially is sufficient. My other question was whether there was any discussion about this at the January meeting. I noticed there's unconfirmed minutes from the 25th, is that right? And whether you had any indication then as to how many people were going?
It wasn't an agenda item,
No.
so it wasn't discussed.
Maybe
there were other issues
maybe
that,
they wouldn't have told you
of
even if
contention
they
that
were.
were discussed, and this was not one of them.
I also wanted to know, I agree with Councillor Toffelberg about the word reaffirms, and would suggest maybe the word supports might be a suitable, or notes might be a suitable substitution, but I would defer to Councillor Loden on.
I'll second that amendment if it sounded like an
Sorry,
amendment.
what word did you land on? Support?
No, we have to vote on the amendment first. Do we have to amend the amendment?
Oh yeah, sure. If the mover and seconder agree to changing the word reaffirm to, sorry, what was the word?
Supports.
Supports. Is that, who seconded? Sorry, I've lost. So is that supportable? Yes? Okay, that's fine. put the amendment. All those in favour? This is just... Oh, sorry, no, we don't need to retract. We're not there yet. Does anyone else wish to speak on the amendment that now says supports? Yeah. Okay. Look, I will speak just to say that it's great to have a motion that supports a position that I've put at the MRC, because it can be a lonely environment where there does seem to be a bit of a lone voice thing happening there. But I just would like to say that in my role as the Council's representative on MRC, I do believe that the bases are being covered pretty well, and that I'd also have the opportunity to come back and ask more questions on this. That I appreciate what this motion is seeking to do, but I also would like to say that it doesn't necessarily have to come through amendments. It can simply come through discussion with me as the rep if there are particular questions that arise, etc., that you wish me to raise in this forum as the representative, that I'm more than happy to do so. So I just thought I would make those comments, and now I will be putting the amendment in two parts. The first is part 1 and 2. So can I please have a show of hands for those in support of that part of the amendment? That's carried unanimously. And now in relation to point 3, which is about requesting the CEO to write to the MRC seeking confirmation of the council members that will be attending the Interstate Energy from Waste Conference, can I please have a show of hands in support of that amendment? And those against? I declare it carried. Okay, we're now moving on to the notice of motion, higher order waste management. Do I have a mover and seconder? Move Councillor Loden.
Sorry to interrupt. I don't think we've actually voted on 13.1 as amended.
My apologies.
Can I speak very, very briefly,
Yes,
just while we're there, just on the info bulletin, just to note that...
So we've moved the amendment and we are back to the substantive. Apologies. Councillor Toppelberg.
Yeah, just to note that the street tree removal request has made it into the info bulletin for the first time, and I do think it's really useful information, and I think that just as a sanity check for the people who are involved in it at all ends, it's good to note that information will be public, both for the requester and for the action that we take, so that's really appreciated. Thank you.
Thank you. Any further comments on the substantive? Okay, I'll put it. All those in favour? Councillor Fotakis, are you voting? Yes. All those against? Declare it carried unanimously. Thank you. We're up to item 14.1 now, the notice of motion, higher order waste management. I have a mover, Councillor Loden, seconder. Councillor Hallett had his hand up first.
Thank you, Mayor. This notice of motion came about because there has, I realise I've talked a lot of rubbish tonight, but a little bit more for people. There has been some shifts in the waste sector, which is something that is pretty slow moving generally, particularly with the decision taken by MRC to move away from waste to energy. Also just recently, Bayswater Council withdrew their support from the EMRC for their participation in the waste to energy process that EMRC is running. In addition, China has flagged that they will not be taking the same amounts of recycled products, and so when you look around, it means it's going to be a real challenge for councils in WA to deal with their waste. The way we need to do this is through higher order waste management. So this motion is about providing a report back from administration on how they're progressing with the waste strategy, and to look at what things can happen in the future, and also particularly to look at how we can collaborate with neighbouring councils, because we are a small council, and if we do want to look at these higher order waste strategies, we are going to need other larger councils to come with us as well. They might be councils within the MRC, they might also be councils within the EMRC who are also interested in taking similar steps.
Councillor Hallett.
I think I support the notice of motion. I guess just to add that it's timely, particularly in relation to some of the state level discussion and around waste strategy, so it would be good to have an update from the city as well.
Councillors, any further comment? Okay, I'll put it. All those in favour? I declare it carried unanimously. And given that we have no further business for this evening, I declare the meeting closed at 8:23 p.m.